I'm excited to talk about this as well. And, I'm kind of an evangelist associated with utilizing the ERP contract and the ERP contracting negotiation process as really a method for fleshing out, the differences in assumptions that you've got between, how you think your implementation is going to go, and even, beyond the implementation, how your use of that software system is going to occur for the life cycle of your use of that product and the vendor's expectations. And I think, utilizing the contract and specifically the contract negotiation process to kind of cut through those misunderstandings and come to an agreement is something that I'm passionate about, something that I do for my clients. And I want to give you, some tips and just give you an idea of what you need to be thinking about in the context of negotiating with your vendor. Let me just start with a brief introduction, and I think Kyler did a pretty good job. So my name is Marcus Harris. I'm a partner at a law firm that's, I'm in the Chicago office of Taft, Stettinius, and Hollister, which is a law firm with about 675 attorneys and providing full service, legal services to a variety of different types of clients, from Fortune 500s to mom and pops. My career spans approximately 20 years. And what's unique about my experience is that, I've been in private practice. I've represented in private practice software vendors, large software vendors, small to mid-sized software vendors, in a variety of different types of situations, from contract negotiation and contract litigation. I've also been in-house, and I think that in-house experience in particular gives me the ability to have an understanding of software vendor tactics and how to counteract those, and really gives my clients an edge, and I hope to share that with you today, in what's a reasonable negotiation? What can you ask for? What is unreasonable to ask for? What are they never going to give to you? Because again, the process is really a collaborative process where you come out with an agreement that really sets forth exactly what's going to happen, so that when something goes off the rails, you can sit back in your chair at your desk, pull out your contract, and say, no SAP, no Oracle. Here's exactly what you agreed to do, and this is exactly the process by which you're going to remedy that situation. That is ultimately the goal. Okay, so how do you get there, and what are you up against? Well, you're up against a variety of different issues. Let me get to the right slide here. I think without a doubt, your ERP implementation is going to take longer than expected. I think most of them do. It's going to cost more than you think it does. It is going to. It's going to exceed your budget. And unfortunately, I think most customers, most clients of mine, don't realize all the business benefits that they thought they were going to realize when they were sold the software, certainly, and during that implementation process. And I think you just have to understand also, the scope and scale of the operational disruption that is going to take place. In the goal here today is, how do you use the contract document, the contract negotiation process, to give yourself what I would call a dog in the fight, to minimize, all of these issues from taking place. I don't think you can preclude them from taking place, but I think you can minimize the impact that they're going to have on your business, and utilize that contract in a way so that when these things do happen, you've got a remedy, a resolution, a path forward to mitigate the impact of some of these unexpected issues coming up. Now, I want to talk kind of as a springboard about a client of mine, LK Plastics. And I can't get into too many specifics of this particular case because it's all confidential. There was a settlement agreement reached with Oracle late last year, so I can't talk about the specifics. But I want to use it to talk about some of the generalities. I'll talk about some of the specifics. I'm not going to go into excessive detail, like I said, but what I will share with you is publicly available. You can go onto the court's website and pull the complaint and take a look at it. If anybody wants to have access to that document, they don't have access to Pacer and the like, I can certainly send that to you via email if you're really interested. So this situation, LK went on a search for a new software provider. I can't remember the provider they were, their legacy ERP system. I think actually it was Texas, which is maybe a second tier or third tier software provider. They were unhappy with the direction it was going. It was going to be sunsetted. So they went on a search for Oracle, or a new replacement rather. They settled on NetSuite, which is owned by Oracle. And they were very much sold, all the sizzle associated with, the software, all the functionality that it can do, all the amazing things that this cloud product was capable of. They embark on an implementation project that has a number of issues that come up, pretty much similar to the issues that we just talked about. But lo and behold, they get to a point where they're starting to test the system, and the system can't process any transaction within the software for the customer, for the client, at a rate faster than something like 15 seconds. It was shocking. So while 15 seconds for a processing time may not seem significant, I mean, if you think about it, if you hit send on an email, right, and it takes 15 seconds to send, or you hit save on a Word document. These are the applications I use on a regular basis, right? As a lawyer, it takes 15 seconds to send. That's going to be problematic. In a scenario where you're processing, hundreds of thousands potentially of orders, or even hundreds of orders every day, and you multiply that by 15 seconds. I mean, that can have a very significant impact on your business, right? I mean, it could potentially take you down. So you've got to remedy that situation. So here in this situation, certainly, the client goes to Oracle and says, hey, well, you've got to fix this. And Oracle says, okay, well, we'll try to get that processing time down. They go through some iterations. It gets to a point where, they do bring down the processing time, but it's never something that, in our client's view was suitable for modern commercial needs, right? So, what does that mean? I mean, I think, here, I think when you go into these implementation scenarios, and the reason why they can fail is you can have there's going to be a resistance to change. And I was listening to the last presenters, and they talked about change management. And I think that kind of carries over to this as well, but it's a little bit different, right? I mean, this is a fundamental aspect of the software that is not working the way it was represented to work, or it doesn't work in a way that actually supports your business in a way that allows you to continue to conduct business in an efficient manner. That's a problem. That's not you being unwilling to change, I would argue, right? But I think certainly your ERP project can fail to the extent that you're not willing to adopt the way that software, the business flows in that software, right? There's going to have to be some kind of modification or change in the way that you do business to adapt to that software product. Now, I will sometimes have clients, and in this case, this is not that scenario, where they're so unwilling to change. What they want is to make massive modifications and customizations to the underlying software so that it essentially functions the same way as their legacy system, which to me doesn't make any sense. Okay. First of all, that is going to cause massive disruption in the implementation. You're not going to get the business benefits associated with the modern technology that you're supposedly implementing for those benefits. You're trying to replicate, in most cases, a 10-year-old system. That is a recipe for disaster. And I think from a contracting perspective, you've got to have an understanding of what the scope is, what your business objectives are, and we'll talk about all these things in more detail in a little bit. But you've got to have a really clear laser focus on what you are getting out of the software, what you want it to address, and really why you're implementing ERP software in the first place. Choosing the right integrator, certainly it's important, but it's not. It may not make or break the situation. I think in this particular case where you have, a piece of functionality that just doesn't work in the way that it was either represented or the way that you expected it to work, is a different vendor, a different integrator, implementer, consultant, are they going to be able to modify that in a way that addresses your particular scenario? Probably not. I think choosing the wrong integrator is going to have a substantive impact on your project in a real negative way. But choosing the right integrator is going to kind of keep you at status quo, I would say. I'm sure somebody's talked about this because it's talked about in seminars like this all the time, but executive misalignment can certainly kill your project, right? So, I think in LK's situation, they caught it early. There was executive involvement from, during that implementation. I won't say from the beginning necessarily. I think maybe there could have been more executive alignment, executive buy-in, and executive understanding from the very start of that project. But certainly they were involved enough to realize what was going on and make the informed decision as to whether they're going to continue down that path of modification and customization to get that software to a place where they wanted it to be, or they were simply going to walk away. Does the software work? I think in most of these situations, the software works. Okay, you're implementing Oracle, you're implementing SAP. These are products that have been put on the ground in virtually every continent, hundreds of, if not thousands of times over and over, for a variety of different types of customers. So, does the software work? I think the answer to that question certainly is yes. Now, it may not work for you, and it may not work in the way that it was represented to work for you. It may not address all of your business requirements. And that, that's a different scenario, right? But in my experience, having negotiated thousands of these types of contracts and litigating, dozens, more than dozens of substantive ERP failures in courts across the country and before arbitration panels all over the country, if it's going to fail, it usually isn't a technology issue. Okay, and I think that's good news from a contracting perspective because you can't contract around a piece of failed technology, but what you can contract around and what causes these implementation failures more often than not, it's a people issue, right? It's a process issue. So if you can utilize your contract to mitigate the likelihood that people are disconnecting, are not living up to the obligations that they have told you they're going to live up to, you're going to put yourself in a good position to avoid certainly an implementation failure. And again, I want to go through kind of what a typical implementation dispute looks like, because I think with that context behind you, then we can start talking about the contract in a little bit more detail. Okay, so all of these failures are different, right? There's a different piece of functionality that doesn't work. There's a different type of representation. There was an aggressive salesperson. Whatever it is, there's going to be something factually different associated with your implementation failure or your implementation than there is somebody else's. But in general, all of the ERP implementation disputes, lawsuits, problems have kind of a similar trajectory, and they usually have a handful of similar allegations that are made by the customer. Okay, and the first one is, look, the people you gave to us lacked experience. They didn't have the skill set to implement the software. They didn't understand our industry. They were never on site. They were remote. They were in Pakistan or the Philippines or whatever it is. What we were promised as a customer was the A team, right? But what you actually gave us was not even the B team. It was the D team. You used our implementation as a training ground to get your inexperienced consultants up and running. So to get them to the point where they could be utilized on other more important projects, perhaps. Now, and we see this a lot. The challenge with these disputes is when you point the finger right at the vendor, there's 3 or 4 fingers pointing right back at you, right? So the typical vendor response to this is something like, well, the customer's project manager and decision makers, they weren't available when we needed them. Okay, there was high employee turnover during the project, so it's not that we didn't have a lack of experience; it's that you didn't have a consistent workforce dedicated to the project. You didn't have an understanding, or your team didn't have an understanding of how the business was actually run, and moreover, your team didn't have the power to make decisions when we needed them to make decisions. They weren't fully invested in the conversion, right? That's kind of the way it's going to go, right? We will put something like this in a complaint asserting that, hey, you guys didn't have the experience. The response back will be something like that. One of the big ones is, look, your salespeople misrepresented the software's ability, its functionality. They misrepresented how the software was going to address our needs. Okay, this is almost always a part of any ERP implementation dispute, and it's a hard argument to make, but it's something that you've got to make from a strategic standpoint, because and this goes back to the contract. The contract that you're going to get from a vendor is typically a form contract that they will dissuade you from trying to negotiate in any substantive way. That will say everybody signs it. It's not our business model is not to negotiate this particular issue. So the contract is worse off than you think it is if you're going to try to make these allegations later down the road. God forbid your implementation fails and you've got to hire an attorney. And so the key here is you've got to get outside the four corners of that contract, and making an allegation of fraud or negligent misrepresentation is one of the best ways to do it, because all of those provisions in the contract that are not favorable to you, they all fall to the wayside. Okay, so this narrow limitation of liability, the narrow remedies that you're afforded, they all go away. And just by simply putting this type of an allegation in a complaint, in a demand for arbitration, whatever it is, in a letter, a demand letter, it's going to make their heads snap back, and they're going to understand that you know what you're doing, you're serious. But it's challenging. It's challenging for a variety of reasons to win on something like this, or to make this argument successfully. And primarily, they've got a lot of good answers for this. Okay, they're going to say, look, the software met the agreed upon acceptance type criteria. The software performed as warranted in the contract because it substantially complied with the documentation. And we'll talk about warranties a little bit later. And that's an interesting one when they say it complied with the documentation. I'll bet you, dollars to donuts, so to speak, that you will have never seen that documentation, right? Or that the documentation doesn't talk about, the particular disconnect you're experiencing with the software. In addition to saying that it complies with the documentation, they will say that, the software and the functionality were demonstrated to you. You had the ability to look at it. And then they'll say, that the software sales process was open, it was transparent, and your expectations are just unreasonable. Another typical allegation when these things go sideways is, look, we flipped the switch and we can't use the software. There's excessive processing times. We can't ship products. We have to have massive overtime for employees so that they can actually process transactions within the system. We can't comply with state or federal regulations. We're losing customers, whatever it is. I mean, it's a parade of horribles, right? I mean, we represented a few years ago with a very large tier 1 software implementation, a pet supplier, a supplier of pet products. Okay, a very large one that you're all probably familiar with. They flipped the switch, and all of a sudden they couldn't process their credit cards. They couldn't contact their customers. They had to get a call center to deal with all of the complaints. And ultimately, what ended up happening is, because there were overcharges on credit cards, people actually called the police. And the police actually showed up at their corporate headquarters asking them what was going on. So I mean, this stuff is substantive and it's real. And again, I think the standard vendor response is the software works, right? You as a customer just failed to re-engineer your business processes, or you didn't implement organizational change so that you could actually use the system. You wanted this system to function the same way that your legacy system functioned. That's the typical kind of back and forth that you would get with this one. So how do you avoid these things? Okay, and then more importantly, let's talk about how you kind of can put these issues or address these issues within the contract itself, right? You've got to define clear project goals, right? What do you want out of the ERP system that you're implementing? Why do you want to implement the ERP system? You've got to identify and you've got to quantify opportunities for improvement in your current business state. I think what we will see sometimes is companies that just want to implement the latest and greatest technology. They've been on their legacy system for 10 years. They don't have an understanding of why they want to implement the software. It's just a technology thing. And if you're implementing an ERP system to get the latest and greatest technology, you're really going to do yourself a disservice, and you're setting yourself back. And I think you increase the likelihood of a failure because you don't have a clearly defined goal. You're just chasing something. You have nothing that's measurable. You've got to define your business requirements, certainly, right? And ideally, those business requirements, to the extent you can, are going to be incorporated into the contract. I think it's critical that before you even evaluate, and certainly before you select a software system, you have to have an understanding of what your business requirements are. You need to focus on your current business processes, and clearly you've got to identify how those things can be improved. You've got to involve key employees, right, in the selection process, the implementation process. And I think one of the most important things is you've got to prioritize your deal breakers, and you can't make assumptions. In this LK scenario, they assumed that any modern software was going to be fit for modern commercial needs, and part and parcel to that would be that it would be fast, right? I mean, modern software is fast. That should be a given, right? But it's not, and you can't just make that type of assumption that the software is going to be fast enough for your business. You've got to understand, okay, the business today, we process transactions in 2 seconds, and any kind of replacement ERP software system needs to do that too, because if it doesn't, we're going to have an issue, which is what happened in the lawsuit that we talked about earlier. But I can't really fault them. I mean, I think that's such a bare basic requirement that you would assume that the software would perform transactions in a reasonably fast manner. It's almost like you go buy a car, you don't have to make an assumption that it's going to come with wheels, right? You don't assume, or you make an assumption that it's going to come with wheels. You assume that it's going to have an engine, right? But in this context, I think you have to be very careful, and you have to make sure that you have prioritized your deal breakers and you have written them down. And ideally, they should be incorporated into the contract. Anything that is important to you needs to be incorporated into the contract as a representation or a warranty. It needs to be included as an exhibit to the contract that the software is going to do X. Because without that, you're putting yourself at a massive disadvantage, and your attorney as well. I mean, if we have to litigate on the basis that something was important, and the other side, which is what happened in this Oracle case, it can just repeatedly say, well, you didn't write it down. You had an opportunity multiple times before you bought the software, and then during the implementation process to tell us that was a critical requirement, but you never did. That's a hard argument to win, right? The response to that is, well, we just assumed that it was going to be fast enough for our business. So, that's a significant issue that needs to be addressed. Prioritize your deal breakers and put them in the contract. All right, so negotiating contract. I think the overall contractual structure that you're going to run into is really going to be either a 2-contract scenario, substantive pieces of this. I mean, there could be many pieces to it, but the main contracts are going to be, first, you're going to have either a kind of a traditional software license, or in this environment today, most likely you're going to have a SaaS agreement, right? But regardless what you call it, all of these issues that we've highlighted up here are going to generally be the same. Okay, they're going to run through the agreement, whether it's a software license, a traditional on-prem license, or a SaaS agreement. There's going to be different flavors, and we can talk about those to some extent. But every SaaS agreement is going to have some kind of license concept incorporated into it, because you're getting the limited right to use a piece of software, a piece of functionality, a piece of technology, whether you want to style that as a service or not. You still have to have a limited ability to use it. Okay. Now, the overarching goal of the software company is to restrict your access to that service or to that software as much as possible, so that they can preserve their revenue streams on an ongoing basis. That's how they make money. Okay, that's one of the ways they make money. So, every person that touches that software, every time another piece of third-party technology accesses it, they want to be able to charge you a fee. And so you have to understand what the scope of the license is. That's just a fancy way to say, well, what can we do with this piece of technology? What are we allowed to do? Here, I've highlighted 3 things that I think you have to ask. You've got to ask yourself, and you've got to ask the vendor, who can access the software? Okay. Now that seems like a fundamentally easy question to answer, right? But it's really not. Do you have affiliates? Do you have independent contractors? Do you have subsidiaries? Okay. Is there a fee for them to access the software? Are they able to utilize it without violating the contract, violating the terms of that license? What about your third-party providers that are providing services to you, who might need to access the software to be able to provide those services to you? You've got to have an understanding of what the scope of the license is. Your goal in this contract negotiation process very much should be to get all the indicia of ownership with respect to that piece of technology as you can, so that you have the maximum flexibility to utilize this technology on an ongoing basis while minimizing your cost, the cost associated with utilizing it the way that you want to use it within reason. Okay, so the key here is minimize cost or understand costs, and maximize the flexibility. So who can access it is incredibly important. You want to have a wide scope of use. And then you want to know, well, how can they access it? What does access actually mean? Is it a user-based kind of scenario? Is it named user, concurrent user? What about third-party pieces of technology that come in, pull information from the system and then pull it out so that we can manipulate it? Does that cost money? Does that count as a user? And then fundamentally, how much does each of one of these access points cost in real dollars? That's all basic information that you've got to have an understanding of. But if you don't, and you make these assumptions that you've got some kind of broad scope of use, and you violate that agreement, they're going to come after you. They're going to audit you, and they're going to charge you a tremendous amount of money. And I recognize some of these names here. Some of these people I've worked with before at some software companies, but I'll tell you, I've dealt with software vendors, software salespeople on a regular basis throughout my career, and sometimes they've got to make a number, and what do? They audit you to be able to figure out where some additional revenue is. You don't want that to happen to you. Okay. The next thing that I think you really want to focus on when you're negotiating these contracts is the warranty. There's a variety of different types of warranties that you should include in the contract, but what I want to talk about now and focus on primarily is what I would call a performance warranty. Okay. What is the software going to do? How is it going to do it? And what happens when the software doesn't do it? What's the remedy for a breach of that warranty? So first, warranties all warranties are going to be, performance warranties are going to be a warranty of time, and it's going to be a warranty of reference. Okay. So how long is the warranty going to last? Okay. And then what is it warranted against? So you want to have, the longest time component that you can possibly negotiate. What's reasonable? Well, I think you've got to look at how long the integration or the implementation process is going to last. And ideally, you want the warranty to last, a certain period of time after you're actually able to use the software. It doesn't do you any good to have a 3-month warranty, but the go live date is a 1.5 years out, right? That doesn't make any sense. You've got to account for that. You've got to make sure you've got a real warranty and not something that's illusory. I think, keying it into something like the date, the go live date, 6 months, a year, 2 years. I've seen not often anymore, but sometimes perpetual warranties as long as you're providing support or you're paying for maintenance or support. Some companies will do something like that. Okay, but the goal here is to get a meaningful warranty that lasts for as long as you can potentially negotiate. I think a 6-month warranty is probably pretty standard. I think you that should be the baseline, and I think you got to go up from there, and then it's whatever you can get. But the key is, that warranty that can't start ticking from the date that they deliver the software to you. It's got to be from the date that software is usable, the go live date, ideally.
Marcus, sorry to interrupt, but we've got a ton of questions over here from the audience. So I thought we might jump in with just a few of those, and we can get back to the overall presentation if you don't mind. So one here that I'll start with is, you talked about kind of reaching the point of no return, so to speak. How do you know when you need to return, so much so that you need to evaluate bringing in legal counsel or support?
Right. That's a good question. I think there's always, there's 2 points of no return, right? There's a point of, there's a tipping point as to when all the little, the 1,000 cuts equal a failure, right? And how do you know when you're at that failure point? It's incredibly difficult to know. But there's always going to be, through the course of discovery and the course of the analysis of the implementation project, there's going to be a point of no return. And I think a lot of times, unfortunately, and that's one of the reasons why these cases are so difficult, is there's blame to go around, right? But there's going to be a tipping point as far as, which party was the most responsible for not doing what they were supposed to do. Which party had the inexperienced team that was, falling asleep during meetings, wasn't providing project status updates and the like. That kind of thing, you've got to look at as far as a tipping point, is to determine who was responsible. When to get legal counsel, I think, ideally, that leads into a couple different things, right? From a failure perspective, I think, when you're having difficulty, when you seem to be spinning your wheels, when you're spending more money than you anticipated or were promised to spend, you're exceeding budget by a significant amount, and nothing's happening, I think that's when you've got to bring an attorney in and talk to them. In that kind of a scenario, when I talk to my clients, I say, have you given it your all, right? I mean, I think you've got to do everything you can, spend what you can spend reasonably to get this thing right-sided, because you don't want to have to litigate. Litigating against Oracle is no joke. Okay, they're going to send a 2,000 attorney law firm up against you, billing at $1,000 an hour. There's going to be 5 people on their team. There's going to be millions of documents to review, and it's going to cost an incredible amount of money. I would rather have my client take that amount of money they'd spend on legal fees litigating, putting it into the implementation project and getting it to where they need to go. Because if you say you abandon the project, you go down the path of litigation, you're looking at spending anywhere from $200,000 to $1 million if you were to go all the way in legal fees. When you could spend half of that, hopefully. I guess it's a cost benefit analysis at some point, figuring out how much you're going to spend to get that thing right-sided. But I think you've got to do what you can do to get that thing on the right path before you take it to litigation. And if you've done everything you can, then I think you take the next step, and that's to sue.
Absolutely. Yeah. And you are only allowed to fall asleep in meetings if you have 2 toddlers, like both Marcus and I do. So that's the only time that's ever allowed.
That's right.
But a specific question here: what about contracting on projects by the specific stage of the project, or at least split the contracting between the quote unquote analysis phase and then contracting for the rest of the project? That this feedback allows both the SI and the customer to mutually understand each other better and outline the risks before engaging further. So kind of that pre-contract, trial contract model, if you will. Is that something you've experienced?
Yeah, and there's a variety of ways to do that. And I think the way, well, let me tell you what I don't think you're talking about first, so we can dispose of that one first, and then we'll talk about what I think you're talking about. There are ways to do trial license agreements, trial SaaS agreements that you can utilize to get a flavor of what it's going to be like to be on that system and figure out if it works for you. That's something that's certainly an option that most people don't utilize. And it's not incredibly common, but we've certainly seen it. There's some kind of an option associated with that, a future option to go live on that software, and discounts and payment fees and schedules and things like that. But I think what you're talking about, is a scenario where you scope the project. There's a blueprinting phase. There's a discovery phase. You kind of come to a mutual agreement as to what's really necessary. And then once you've got that mutual agreement, then you go to the integration or the implementation of the system on a full-scale basis. And I think you can do that, but I think you've got to do that in the context of already having put in place and spent the time negotiating a master services agreement. Okay, because in that scenario, all you're doing is negotiating individual statements of work for different phases of the project, and I think that's certainly fine. But what you don't want to do is negotiate a full-blown contract for one phase, throw that out the door and then do another one. But I think you can certainly do that, and I think there's some benefits of doing that, so that everybody has an understanding of what they're getting into. But we talked about, and I'm not sure if I finished the thought or not. Hopefully I did. The contract structure. You've got the software license SaaS agreement. That's one component of it, right? And then you've got the MSA, the consulting agreement, and then the associated statements of work. And I guess potentially you've got change orders associated with those too. But so there's a contract structure here, and if you don't have the software, which you've got to negotiate that contract, you don't really get to the implementation phase and having the MSA. And it certainly depends on how you do that. Depends on if you're going with one vendor for everything, so you're going to go with SAP and SAP's professional services organization, or you're going to use a third-party integrator, and you're going to use software A and software B.
Absolutely. That's a great answer, and a really interesting scenario that I've never heard you talk about. So thank you for that great question. Let's do one more, and then we'll let Marcus get back to his presentation here. So we have one that I think is a good question. Do you find that the length and cost of the implementation is a bigger reason for failure than the actual software chosen?
I think, for a simple answer, yes. Okay. I think certainly the software that you choose is going to be a key component, right? It's got to be compatible with your business. But is there a substantive difference between SAP product and an Oracle product? I'm not really sure. Okay. Like I said, the software works, but I think the longer that you take to implement that software, the more problems you're going to have naturally, right? I think was it Little that had, I forgot how long they took implementing that software, but it was years upon years, and millions of euro later. And in that failure, they didn't understand how the software processed the retail price versus the taxed price or something. It was some scenario like that. It was a super simple thing, but they couldn't get the software to do that. But they had spent all this time to get to that realization. So I think, there's a balance, right? I mean, you don't want to take years upon years to implement the software, because I think there's more things that are going to go wrong. And that to me is indicative of a problem in and of itself. But you also can't fast track this thing and do it, in an unreasonably short amount of time. That's a problem too. So I think you've got to have a realistic understanding of how long it takes others in your industry that are similarly situated to implement that particular software. And you've got to kind of use that as a basis for your frame of reference.
Absolutely. Great questions, folks. Great answer, Marcus. We'll let you get back to the presentation here, and I'll keep monitoring these questions. So please continue to drop them in the comments.
Yeah. Hey, Kyler, how much more time do we have here? I want to make sure I've I get to everything, and I also want to make sure we answer all these questions.
Sure, absolutely. So we had started at 10 after.
Okay.
So that's probably what we'll go to, about 3:10 Eastern time, if you can. But again, we want to hear what you want to say, and I think the audience would agree. So we can always, go a little longer as well. And then I can just ask you questions too if you want to go that route. But definitely want to hear what you have to say.
Okay. Well, let's kind of finish up the substantive part of the presentation, and then let's get to some questions too, because I think these questions are really good. And in some ways, they're a little bit more interesting sometimes than kind of a, well, I think I'm one of the most interesting, attorneys you can talk to. Not everybody.
Absolutely. I agree with that. I would say I'd give you the title of the most interesting attorney I've ever spoken to. So.
Well, thank you. Thank you. So we were talking about warranties, and I think this is an important feature of the contract. It's one of the most important ones, right? Because it sets forth what your expectations are of what the software is going to do and how you measure that performance. And we talked about time, when does the clock start ticking on that warranty, what's reasonable, how long it's going to take. The second component of a warranty is this reference. And this is critically important. Most software vendors are going to represent that the software is going to substantially conform to the documentation, okay? And good luck figuring out what documentation means or what it is. It's going to say something like, the instruction manuals that are provided under the agreement. Ask for them, during the contract negotiation process and see what happens. Most likely, they're not going to give it to you, okay? So you're going to have no idea what it says. In some ways, it's illusory. So what you need to do, to the extent that you can, and it all depends on leverage, how much money you're spending and how important you are as a customer to that software vendor, what you have to do is try to incorporate whatever representations were made during the sales cycle, during any kind of interaction that you've had with them. You want to be able to attach those as an exhibit. And it particularly, if you have identified, one of these deal breakers, there's nothing that's going to be more powerful that, hey, look, you promised that this software was going to perform transactions in the system, whatever it is, invoicing, whatever, within 3 seconds. Okay. You want that representation covered, because there's nothing more powerful for your attorney to do in the face of alleged noncompliance, to point to a written document and say, well, we agreed that this is what you were going to do. You get to this Oracle scenario where they were like, well, you never wrote it down. You never told us. It's going to be a he said, she said kind of scenario. And that's never a good place to be. So if it's important to you, especially if it's one of the deal breaker issues that you've identified as to why you're making the transition to a new system, put it in the contract and make it a warranty or make it a representation so it's contractually enforceable. If there's nothing else that you walk away from from this presentation, I think that's probably one of the most important things. Get these things into the contract and make sure that it's something that you can enforce against that software vendor in the future. Another practical issue is, what are you licensing? Okay. There's so many buzzwords, SAP HANA, what is it? R3, what is that? There's so many, so much branding, trademarked words. What does it mean? And if it's not sufficiently detailed within the contract itself, you may not actually have an understanding of what you're licensing. And the problem with that is that you may think you're licensing A, B, and C functionality. And by the way, you may actually have access to A through Z functionality just by simply logging into their system. But you may not have access to any of it, and you may be under the assumption that you actually do. You need to make sure that it's not just some kind of brand name software product that's identified in a schedule. It's got to be, here's what we're licensing, here's what it does. There's got to be some clarity and some teeth around the description of what you've actually licensed and what you have a right to utilize. And then in that same vein, it's got to be comprehensive. Just because you're licensing a product doesn't mean you get upgrades for no fee. It doesn't mean you get updates. It doesn't mean you get bug fixes. You've got to make sure that all of this is rolled into what you're actually licensing, what you're able to utilize. And that goes for customizations as well. Any kind of deliverable that's provided during the implementation process, you've got to make sure that all of that is rolled into the license grant in the definition of what you're actually licensing. A note about upgrades and updates. As more and more people utilize SaaS software, SaaS software is great. Okay, I'm not one of these evangelists that think it's the be all and end all and it's fixing the world. I think it's good for certain people, and I think for certain people it's not good. But if you're a customer that is on a SaaS product and that vendor is rolling out updates and upgrades on some kind of a calendar schedule, you've got to make sure that fits and aligns with the way that you conduct your business. I represented a very large retailer, a clothing company, manufacturer, distributor, and retailer of a very popular piece of clothing that most people are probably wearing today. And one of the big issues in a dispute that we had with their software vendor was that they would continually push upgrades, substantive upgrades to that system in December, right when it was their busiest sales season. And so now, all of their employees have to get used to new functionality, new methodologies of doing things within the software. It may not have been incredibly substantive, but it was enough to have an impact on the way they conducted business, and it was enough to impact revenue and performance. So something to think about is what do you have access to, and when do you actually get access to it? Okay. One of the other huge things in the contract, and I think any attorney, any commercial contracts attorney, is limitational liability. And simply put, you don't, as a business person, want to get into a contract that subjects you to unlimited liability. Okay, that can take your business down. Most vendor contracts are going to be one-sided. They'll limit their own liability for anything that goes wrong, and it's usually to the fees paid that you've paid to them. But they will subject you to unlimited liability. So if you breach the contract inadvertently, let's say, now they've got a claim against you for potentially millions of dollars, and you've only paid $100,000 for that software. That doesn't make any commercial sense. So you've got to have an understanding of what's reasonable. And typically what's reasonable, in my view, from a customer perspective, is to limit your liability at the amount of fees paid under that contract. Okay. And remember, we're talking about the software component right now. We're going to talk about the services component in a second. Now, from a vendor perspective, they're going to push for you their overall limit, and they'll agree to do it mutually, to something like a 3-month period, the 3 months prior to the issue giving rise to the claim of liability, to the lawsuit. Okay. So they're going to, instead of, $1 million is what you paid for the software, it's going to be, the amount of money that you spent in the last 3 months to 6 months or a year. Okay. And that might be enough. That might be okay, but it's not going to be okay for everything. First, you may not have paid them any fees in the last 6 months or the last year, right? The fees may have been, front loaded, so to speak. And so there's nothing there, you have unlimited liability by default. Or you may have paid, for services fees or some other type of fee. So, you've got to pay attention to that as to, what the limitation of liability is and what your scope of recovery is. There are certain things that you're not going to want to have a limitation on. So if they were to post your proprietary information on the internet, your confidential information, your trade secrets, violate those types of rights, those are not easily quantifiable monetarily. So it's typically not something that you would put a cap on, a monetary cap. Data breaches, do you really want to limit their liability for a data breach? Probably not. And to the extent you do, there's things called super caps that people will agree to. So, instead of fees paid, it's 10 times fees paid or something like that. So there's a lot of different ways to do this. And it's going to be dependent on the type of software, the type of access, and what your risk tolerance is in that particular scenario. The next issue is that you've got to focus on really, price increases. Okay. And I'm trying to give practical things. We could talk about a lot of, esoteric legal issues associated with this force majeure and, all sorts of things. But I think if you focus on these real world issues that most people have a concern with, you're going to do pretty good. Okay. So, how much are you paying, right? It's critical. But I will tell you, in the context of pricing, you've got to be careful, because I think you can be a penny wise and a pound foolish. Software vendors are notorious for giving you some massive discount off of list, and to the extent that you have negotiated one, it doesn't really mean very much. All right, you may think you're the best negotiator in the world, but in reality, they may have given 100 other customers the same type of discount. List price is illusory. Okay, I think you can be better served by paying close attention to the management of your relationship with them contractually over time, from a pricing perspective, because I think you can, if you hold their feet to the fire, you have an understanding of what your scope of use is, how you're going to be charged. You understand, what the software is supposed to do and what happens if it doesn't do that. Those things ultimately could save you more money in the long run than some kind of big discount off a list price. But regardless, bringing it back to price increases, I think you want to have an understanding of what your overall spend for that particular piece of software. I think in the SaaS world, say you've got a 3-year term, you want ideally the price of the software to be fixed for that term, and then after that there should be some kind of a cap on their ability to increase the software fees. Okay, and it could be something like CPI plus 5. I mean, it just depends on whatever you can negotiate that's reasonable, but they shouldn't have the unfettered ability to just raise prices on you. Right? There should be some limitation. Termination. You never want to get into a contract that you can't get out of somehow. Now, the challenge with this issue is that the vendor wants to lock you up for as long as they can. Okay, so if they can subject you to a 7-year term, that's much better off for them, right? But you want to be able to get out of that contract, within reason, in a fairly quick period of time. Your needs have changed. There's a better piece of technology that fits. So you're going to want to have a short duration, and you're not going to want to have any continuing payment obligations to them. You also want to have an understanding of what happens to your data. Is there going to be some kind of a transition assistance to get you from that system to another system? And that's something that you can negotiate. There may be a fee for that, but that's something that should be in the contract. All right. Let's talk about the statement of work. I don't want to give a short shift to this, but I think I'm going to have to, because I think this is probably the most important document in the bundle of contracts that you're going to negotiate. In every statement of work, there's going to be an assumptions section that is going to be one-sided and unreasonable. Okay, the vendor is going to shift almost the entire responsibility for the implementation onto you, and say something like, we as the vendor, we are providing services at your direction. Okay, that's somewhat true, but there's a reason why you're hiring them. Okay, so the assumptions in the statement of work are critically important because they set the stage for who has the responsibility for the implementation or the integration. And if all of the risk of that business transaction is put onto you, you've got to renegotiate that and make that fair. Okay, I think it needs to be balanced, and it can't be just put all on your shoulders as the customer. Some practical things that have got to be in here, and I think some of this is common sense, but so many times we don't even see it. Okay. Or we never even see the statements of work because our clients don't send them to us. There's got to be an estimate as to how much it's going to cost. And let me kind of take a step back and set the stage. I mean, and somebody asked the question earlier. I mean, there could be multiple statements of work, right, for different phases of the project, and I think that's certainly fine. Or there could be one statement of work for the duration of the project. It depends on the nature of the project and how you negotiate. But regardless, there's got to be an estimate as to how much it's going to cost. You've got to know, how much you're going to spend. It can't be just, a free for all as far as, it's going to be time and materials, and, it's going to be whatever we say it's going to be, because, look, these vendors are, many times in the contracts that we see in the litigation that we're involved in, they're like, drunken pirates on the dock, sipping, rum, the rum being the billable hour, right? And that's how they're incented, and that's what they want. All due respect to, any vendors on the line, but we see that a lot, and certainly not all vendors. The scope's got to be reasonably detailed. Okay, you have to have an understanding, of the deliverables, what they're going to do, when they're going to be provided to you, deadlines, milestones, all of that stuff has to be included in the scope. And more importantly, what's out of scope? What are they not going to do? Okay. There should be a detailed change order procedure within the body of your statement of work that sets out, okay, if something's going to be outside the scope, how are we going to deal with that? And ideally, in the documents that we put together, there's a detailed process, and it lays out, here's what the change order is, who's got to approve it, here's the change, here's the scope of the change, here's how it impacts the original scope, here's how it impacts the budget, here's how it impacts any deadlines or milestones, and here are the deliverables. Okay. Speaking of deliverables, you have to have an understanding of what those deliverables are, right? That seems simple, but there's got to be a definition. What are they actually obligated to provide to you? And there should be a whole process associated with that. There's got to be a business requirements document. There's got to be some kind of analysis. There's got to be specifications for it. All that stuff should be signed off on with respect to a particular deliverable, depending on the type of project and how sophisticated it is, certainly. But just as important, there's got to be a process for accepting and rejecting deliverables. Okay. And to some extent, I think with the software itself, ideally, but certainly with respect to deliverables, there's got to be a period of a deadline for when they're going to deliver the deliverable. There's got to be a process for you being able to evaluate whether that deliverable complies with agreed upon specifications for the deliverable. And more importantly, if it doesn't comply, what happens? Okay. Do you send them, a notice of noncompliance telling them what's wrong with it? Then they go back and they fix it. Okay. They redeliver it, doesn't work again. How many bites at the apple are you going to give them? And if they can't fix it, are you going to get a refund? Is it going to be a refund for the whole project? Do you get to terminate the project? Do you get a refund for that particular deliverable? All of these things should be well thought out and put in place in the contract so that you've got the methodology. When things go wrong, you've got a basis for understanding the process of how to get things back on track. Like a software contract, the services contracts and the statements of work have to have their own warranties and remedies. Okay, and I think they're similar, but they're different. As we talked about remedies to breaches of warranty, and I can talk about it here with more specificity, and it's the same for both a software contract and a services contract for the most part. Okay. For a software contract, it's really more of a repair, replace, or refund. So if the software doesn't do what it's supposed to do, or the deliverable doesn't do what it's supposed to do, are you going to repair it? Are you going to replace it? And then are you going to refund my money? And do I get to terminate the contract without obligation? There's got to be some sort of substantive resolution to the breach of the warranty obligation. Okay. In the context of a services warranty, usually it's a reperformance of the service to the extent that it can be. And then if it can't be reperformed satisfactorily, then you get into, a refund or a termination or something like that. But all of that stuff has to be, like I said, detailed in the contract and thought about ahead of time as to, what are they obligated to do? Just as a baseline, what's the performance criteria? And if that doesn't happen, what do we get to do, right? If it's a services contract and they're not performing, are we then going to be able to, engage a third party to finish the work? Are they going to have the ability to access the work that was previously provided? That kind of thing. I think in the context of a statement of work and a services contract in general, you're going to want to have the ability to have some control over their staff. And I think it's got to be reasonable. You've got to be able to review the people that they're assigning to your project, make sure that they've got the requisite level of experience, and to the extent that they're a detriment to the project, you've got to be able to request that they be replaced with somebody that is acceptable to you. That's part of that management process that we were talking about earlier. And then again, there's got to be a separate limitational liability associated with the services component of the contract. And again, you're going to want to get as much as you can because your obligations as a customer are pretty minimal, right? It's to pay your bill. So you don't have a lot of exposure on limitational liability, but they do. And they're going to want to minimize their liability to the maximum extent that they can. Again, 3 to 6 months of the fees paid is going to be the limit of their liability. You're per statement of work potentially, right? So that's I would say ridiculous. You're going to want to expand that to the amount of fees paid under a master services agreement, or at least under a set of SOWs for that particular piece of the project, or at least the SOW, not some sort of a subset. So that's kind of an overview, a simplistic overview of the contract process and the things that you need to be careful of. I've tried to give you some context as to how it comes into be, why it's important, what you're trying to mitigate. I think we could talk for hours about this, really. All the nuances. I mean, there's particular clauses that you can negotiate. There's different fallback positions that are reasonable or that are unreasonable. I mean, there's a lot of information that really doesn't lend itself to an hour presentation. But again, if you've got questions or you've got specific issues that you want to talk about, feel free to touch base with me. I've got a website, softwarenegotiation.com, that lays out some of this stuff. You can look me up on LinkedIn. I've got a YouTube channel, or you can email me or feel free to give me a call. I find this stuff incredibly interesting, and I'm happy to talk about it with you.